All right, looks like the first individual we're gonna have this morning is gonna be Joseph Falcone, followed by Justin Aguilar. Right. And then I've already read through each one of these files, so I'm familiar with the probable cause sheet, risk assessment, and court services notes. So I'm interested in failure to appear, failure to comply, and criminal history. So you don't have to go through the probable cause sheet unless you want to specifically highlight something. Is the state ready to proceed with Mr. Falcone?
Yes, Your Honor.
All right.
Jill, you're muted.
Your Honor, just to ease the process with Mr. Falcone, he does have an out-of-state hold out of Florida. He is submitting to any bail set by the state in this matter, as any amount of bail will be a de facto hold, but there's already an actual hold, so he's just prepared to submit if the state will accept.
Okay.
Yes, I have no problem with that. With Mr. Falcone, we're going to ask for $50,000, as well as stay in Northern Nevada, no weapons, and testing for alcohol and controlled substances based on prior criminal convictions.
All right, I just want to make sure I understood one of the comments that you made. Just bear with me now. You said something, did you say stay in Northern Nevada?
Yes. Again, he's got that out-of-state warrant, and all of his criminal history is out of state. And so if he were to make that bail for whatever reason, that he stay in Northern Nevada during the pendency of this case.
All right, fair enough. I just wanted to make sure I heard it right. Otherwise, I have the same conditions in my JRO. Drug and alcohol testing, shall not possess firearms or weapons, stay in Northern Nevada, and then supervised check-ins with the AS. And I'm also going to appoint public defender for him as well. Okay. Next individual is going to be Justin Aguilar, followed by Jason Brown.
Thank you, Your Honor. For Mr. Aguilar, he did waive his appearance today. Any amount of bail will work as a de facto bail hold. I would say that he is aware that he has 2 open cases, both in Reno Justice, one ending in 1-3. Woo, can't see this morning, Judge, sorry. Older eyes. We got 1-3-2-2-4-4 and 1-3-2-6-5-2. Both of those have cash only at $2,000. The case is pending on 2 failures to appear already on each, and warrants issued. So he is submitting on whatever the state makes. Those 2 will operate as a no bail hold. I would ask if the court would consider it to be commensurate with those, as the charges are similar, and he is unlikely to be released for a $2,000 cash only on this case as well.
Okay. What is the bail that the state wants to set, Mr. Aguilar?
Your Honor, if the court is inclined, I have no objection to the $2,000 cash on this one as well, to make it $6,000 cash. I'd concur with the statements as far as these are similar cases that he's pending on all of them. I could go into his criminal history, but if the court is amenable to that, then I would just submit on the $2,000 cash with DAS and testing.
Then he did have a weapon on him. Do you have a no weapons or firearms clause? He had a knife.
Yes, I think that'd be appropriate, especially given his failures to appear in the past, and issues with coming in contact with law enforcement based on that.
Your Honor, I would ask permission to readdress that should he make bail, simply because I believe that the weapon was a fixed blade and shorter than that 3-inch. It wasn't noted, but it wasn't listed as a prohibited weapon. it was on display on the front of his body. Given that it seems that Mr. Aguiar has fairly substantial challenges with housing, I believe that it is fair and appropriate for him to be able to have a tool that is often used by individuals in order to meet their daily needs on the street, such as opening cans, doing things like that. I know that there are concerns, but it was not deployed in this case and it was visible and non-prohibited.
Well, how do you know that? That it's something that you could use to open a can as opposed to a standard folding blade knife?
The PC sheet didn't indicate that it was a prohibited weapon. Officers are usually very detailed in their PC sheets with regards weapons for that purpose. Also, doing this for 14 years, I just see a lot of stuff in homeless people's bags over time. And those small fixed blade knives are usually pretty common, not for the purposes of violence or assault, but because they come in convenient living on the streets. You'll find them in most hikers' bags too. And I'm not asking that it not be there. I'm asking for the ability to readdress it if he's able to make bail. So I think it's basically a moot point, Your Honor.
Okay. Okay, fair enough, understood. All right, so I've got him subject to testing. And supervised check-ins with DAS. The firearms issue is duly noted in my JRO. All right.
Thank you. And I have no opposition to firearms, just that limited to firearms and prohibited weapons.
Okay, you got that?
Yep.
Okay, so we
Thanks.
made that change. Fair enough. All right, how about Jason Brown? After Mr. Brown will be Patrick Bundy, followed by Everett Newton. All right, is state ready to proceed?
Yes, Your Honor. In this case, we're asking for $20,000 bondable only. The one drug charge is a category B. I would note that the defendant has criminal history going back at least as far as 2001, had a felony conviction for possession of a firearm in that year, had a 19, or sorry, goes back to 1982, had a felony conviction in that year.
And Your Honor, if I can just stop the state, I believe that the 1992s involved juvenile history. As I was looking through it, it seemed like I will acknowledge that there were 28 pages, but that I believe the last 7 pages were related to juvenile history. I believe that that's prohibited from being considered. I would stipulate that there was some no-file charges. There was a significant felony for which Mr. Brown did serve prison time. There are multiple charges in 2023 and a DUI in 2017. I don't believe it's appropriate to go back to the juvenile history.
All right, why don't we just limit it to the current history then, not his juvenile record?
Thank you.
Still substantial, though, but statement proceed.
Thank you, Your Honor. So again, concerning in this case, given the various amounts of different controlled substances, and obviously the length of this investigation as set forth in the PC sheet, I think looking at his MPRA score, it's also concerning given ultimately what types of contacts he has here. That apartment was supposed to, he was staying there, but was supposed to be unoccupied. So I think there's a real risk to, in addition to the risk of the community posed by his lengthy criminal history, and the most recent arrest in 23, I understand there were no issues, but he had the firearm charge in 23 that he was arrested for, and the possession of a controlled substance and transporting case that he was arrested on. And here we have, again, multiple substances, obviously indicative of sales. And so ultimately, we believe he's a risk to the community based upon those allegations, as well as a risk not to appear given his lack of stability in the community. And so in addition to the bond of only bail, we would ask for DAS supervision testing for alcohol and controlled substances, as well as no possession of weapons.
Right, Ms. Meyer?
Thank you, Your Honor. Your Honor, in this case, we understand that his history might give rise to concern. However, the number of no issues, I believe suggests, especially given that I believe this was the RNU, that is a cross-agency task force that appears in plain clothes. We're unable to review some of the footage in those prior cases because none has been documented. We have spoken with family who has concern about the interactions with law enforcement, which is not uncommon. But with those no issues taken in conjunction, I believe bail is not intended to be punitive and intended to establish that nothing other than monetary bail can secure the safety of the community and the appearance of Mr. Brown at court. I would point out that he scores a 9, which is the very lowest end of the risk to either the community or reoffend. We were able to speak with his son, Kai, who is 21 years old. He confirms that Mr. Brown does have a daughter who goes to school instead, that the house indicated on the NPRA is confirmed instead. He has significant ties to the community. He has a number of resources that will be able to be reached out and contacted. We were able to speak with two of them. Given that the communal space was noted in the PC sheet, there may be an argument as to constructive possession. So I think when you look at those old factors pre Valdez Jimenez, we start looking at the 8 factors that mitigate in favor or aggregate against. And in this case, I understand that it is a B, but I don't believe that there is that absolute conviction that a charge will be laid. Therefore, what I would ask in this case is $5,000 or 10%, as the category B felony is not a violence against a human. I believe that regular testing is substantial, and Mr. Brown knows based on the sheet in this that he will be under fairly close observation. And I believe that there is no chance that he will not be monitored closely. So daily check-ins with DAS is also something he could manage. Given that totality under Valdez Jimenez, I don't think the state has shown clearly and convincingly, based on prior history and the allegations alone, that Mr. Brown requires monetary bail in the amount sought. We would ask for $5,000 or cash 10%.
I do have a question for the state, because it is a category B, but it doesn't involve a human victim, firearm, or residential burglary. That's the no 10% cash option, correct?
Well, Your Honor, so I would note that the
I still have discretion.
sorry, what's that?
Said I still have discretion, but I just wanted to make sure I understood. Because the administrative order basically says human victim, firearm, or residential burglary. That's mandatory, no 10%.
Yes, Your Honor, and in the state's view, again, I understand the administrative order regarding the what the court considers generally for no 10%. Obviously, our office differs in that position a little bit, given the fact that it is a category B and potential for elevated prison time. We are asking that it be bondable only. And I would note again, just the defendant admitted there was a backpack in the location, and so understand defense's argument about their position on the factor of likelihood of conviction. But again, given all the factors, I understand it's not necessarily falls within the order, but that is our ask, is that it be bondable only.
Ms. Meyer, you said he lives instead. I have him living at 556 Aurora Court in Lemon Valley.
Forgive me, Your Honor, that is the address. His daughter goes to Stead, but he does do transport. I'm sorry, I confused 2 individuals on my bail cheat sheet.
All right. Well, I actually did the warrant on this case, so I'm familiar with the facts. It is gonna be $20,000 based on the facts in the PC sheet. Given the number of drugs, and he actually admitted the about the backpack, so it's $20,000, no 10% cash option. Subject to drug and alcohol testing, shall not possess firearms. Other conditions is he must reside 556 Aurora Court. In the event that he bails out, and have supervised check-ins with DAS.
37 years says you're gonna make.
Thank you so much, Your Honor.
All right, next is going to be Patrick Bundy, followed by Everett Newton.
So he just ordered DAS supervision, sign right here, I'm gonna give you a copy, it just says you have to make.
Your Honor, if
Alright,
you can
Mr.
still
Bundy.
hear me, Mr. Bundy was unable to appear today due to, sorry, it wasn't Mr. Bundy. Excuse me, Mr. Bundy is right here.
Okay, I'd stay ready to proceed with Mr. Bundy.
Yes, Your Honor. And I see him approaching now. So regarding Mr. Bundy, we are asking for $15,000 bondable bail, DAS supervision, testing for alcohol and controlled substances, no contact with the Galena Creek Park, and no weapons, if I didn't already mention that. The defendant has a criminal history going back to 2004 in Utah, has a history that is indicative of quite a bit of substance abuse. Also, relative lack of ties to this area. So 2004, he had a minor possession of alcohol in Ogden, Utah. Now that I'm checking my math with my earlier comments, I believe he would have been 18 at that time. Had a felony conviction for possession of a controlled substance in Ogden in 2005. Had an arrest for CCW and minor possessing alcohol in 2006 in Sacramento, California. Looks like that was ultimately dismissed, although it's a little bit unclear based on the criminal history. Also had a possession of drug paraphernalia and minor possession of alcohol in Ogden, Utah in 2006 as well. Minor possession of alcohol in Weber, Utah in 2007. Possession of marijuana conviction in 2014 Ogden. Possession of controlled substance and drug paraphernalia in Riverdale, Utah. 2016 is his only real connection to Nevada, as far as I can tell from his criminal history, with a possession of marijuana in Hawthorne, Nevada. And then he had a 2017 arrest for possession of a controlled substance in Roy, Utah, with no disposition. Again, based on the allegations here, it's clear that, the PC sheet seems to indicate that he was under the influence of controlled substance here and acting extremely paranoid, said he broke in to obtain a firearm, which is obviously concerning if an individual in that state does have a firearm. And so based upon all the facts here, again, the lengthy criminal history with substance abuse, the lack of any ties to Washoe County and minimal contact except for that 2016 case in the state of Nevada itself, we believe he's a risk not to appear and believe that the bail and conditions are appropriate. Thank you.
What's the amount of bail that the state is asking for?
Sorry, 15,000 bondable.
So I wanted to confirm, I thought you said 5. All right. Ms. Meyer?
Thank you, Your Honor. Your Honor, I think that the state cannot prove by clear and convincing evidence that monetary bail is required. As I read the criminal history, there are 2 misdemeanor convictions that are approximately 20 years old, both of those for minor in possession, 2004, 2006. I show all other cases ultimately dismissed or with no available resolution in file. I do see that 2016 conviction for marijuana, which is now a legal substance, and that was 1 ounce or less. In regards to this case, I believe that the sheet says he was employed at Tesla. We have spoken with his parents, Ava and Ed, who do live in Utah. However, he has ties to this community. He has a roommate named Miguel. He has not been working at Tesla in the last 2 months, but had been the victim of a prior intimate partner. In that case, there was some violence. He has been trying to cope with some of that. I believe in this case, Your Honor, especially given the fact that he ultimately came back. How he was found is that he came back to apologize and turn himself in at the visitor center. He brought the keys with him. As far as the damage is concerned, I believe that the keys were significantly expensive, but he had those back without damage. And then he drank a fizzy water and ate a granola bar. Ultimately, he also took the law enforcement officers to where his vehicle was because he was concerned about the dogs. The windows were open, but there was no food or water. It is my understanding, given the totality of these circumstances and the acknowledgement by my client and his family that he needs to seek mental health services, I believe the appropriate non-monetary bail security of his appearing is to have him on testing, to have him provide within, it's Friday, within 96 hours proof of evaluation or contact with HOPES and compliance with any mental health court treatment either HOPES or another community resource provides. I believe that that balances it out, as well as those check-ins. He does have a place to live. He does have this mental health disorder, but we don't want to lock up people because they have a mental health disorder, especially where there are indicia that he is not a risk to the community. He does score that 6, and with a verified cell phone through his parents, that would put him at a 5, which is a medium risk to reoffend.
Remember, Ms. Meyer, I'm familiar with the facts in the PC sheet.
Thank you, Your
I
Honor. I'll
did-
cut it short.
Yeah, no worries, but what you did say at the end, I believe is appropriate. So I just want to make sure, were you able to verify that his address is at 3727 Reno Vista Drive?
Yes, that's what we confirmed through Ed and Ava. Though they don't reside there, they are in contact. And they confirmed that he lives there with his roommate Miguel, but we weren't able to speak to Miguel personally. I believe he is at work at Tesla.
But you say he no longer works at Tesla, correct?
No, the roommate, Your Honor. I apologize.
Okay, so he still works at Tesla.
I believe that's the case, but again, we weren't able to confirm that independently except for through Ed and Ava.
Want to ask your client? See if he knows if he's,
He does.
I'm currently on leave from Tesla, Your Honor.
okay. Okay, given this situation as well as his risk assessment, I'm only going to establish this bail. Some bail is appropriate, $5,000 or 10% cash. No contact with the visitor center in Galena Creek, 18250 Mount Rose Highway. Given the circumstance of this case, we're going to require that he be fitted before release with a GPS device. Will be subject to testing. Shall not possess firearms or weapons. He must reside at 3727 Reno Vista Court. He's on leave with it. They must verify his Tesla employment. And I think the point you made, Ms. Meyer, within 90 days to provide a mental health evaluation to DAS, may be subject to supervised check-ins with DAS. All right. Next is Everly Newton.
All right, buddy.
Followed by Carlos Diaz. All right, so before we proceed, let me just confirm something with Mr. Newton. You indicated in your application for public defender that you were going to retain private counsel. Is that still the case?
Your Honor, if I may address this, it is my understanding that Jamie Martinez has been secured in both the RCR 129439 case. Excuse me, in only that case, she is already representing him. I would ask to be allowed to proceed for the purposes of today's hearing unless Mr. Newton wanted to continue it out for contact with Ms. Martinez. Otherwise, we would be prepared to await the determination for all future hearings as to whether will be appointed or retained counsel
No,
will
I
be.
understand. So let me ask him. So I can appoint the public defender for the purpose of representing you in this bail hearing. Because you don't have counsel, private counsel yet, although it sounds like, based on Mr. Meyer, you have retained someone. All right, is that attorney gonna represent you in this case? Do you
No.
wanna wait for him to represent? No. Is it, you said no?
My private counsel won't be representing me in the new PCS charge.
Okay, fair enough. So I'm gonna go ahead and appoint the public defender to represent you in this case. If it changes otherwise, then he needs to file a notice of appearance. All right, so you can give me a public defender sheet. Okay, perfect. Right, is the state ready to proceed?
Yes, Your Honor. So, Your Honor, in this case, we were asking for $10,000 bail, DAS supervision, testing for alcohol and controlled substances, no weapons. The defendant has lengthy criminal history, I believe 16 prior felonies and 4 misdemeanor convictions. His history starts back in 1998 in Oregon. He had a DUI. Looks like he failed to appear twice and had a diversion rescinded in Oregon. Then in 99 had a felony conviction for burglary, had a felony conviction for theft, had 2 parole violations in that case. 2003, a felony conviction for mail theft. These are all in Salem, Oregon. 2009 had a delivery of methamphetamine conviction, had his parole revoked there. I should mention in his 2003 case, he had 10 parole violations, according to the records. 2010 had another felony conviction for delivery of methamphetamine in Salem, Oregon, had parole violations in that case. 2012 had felony conviction for unauthorized use of a vehicle in Salem. He failed to appear twice on that case. Also had a misdemeanor conviction for possession of burglary tools where he failed to appear. Had a 2013 felony conviction for unauthorized use of a motor vehicle in Gresham, Oregon. Had a 2013 felony conviction for looting in Marion, Oregon. And then a felony conviction for escape in Marion. And those are all in 2013. 2018 had a felony conviction for burglary here in the second judicial where he was dishonorably discharged from parole. 2022 had a felony conviction for possession of a controlled substance here in the second. Also had a felony possession of a stolen vehicle that was dismissed pursuant to that plea. Then he had another felony conviction for possession of a controlled substance here in the second judicial. And he was currently, as the court noted with that other case, pending that grand larceny of a motor vehicle, where he failed to appear after having a pretrial violation report in July, where it looks like he had missed some tests, had some issues with testing, and then here, obviously, we have another controlled substance. So the defendant is absolutely a risk to this community. Absolutely a risk not to follow court orders based on his numerous violations in the past, failures to appear having been revoked in his other prior felony cases. And so we believe that bail, even though this is a possession of a controlled substance case, that bail at a higher amount is absolutely appropriate to ensure that he appears in the future. And with that, I'd submit it.
Okay, Ms. Meyer, were you able to verify his personal information, including his address?
Your Honor, unfortunately, at this time, we were able to reach out to Melissa. He had been unhoused. Melissa is checking with her landlord to see if, in fact, he could stay there. Your Honor, what I would submit is I think that the state is correct in its recitation of prior criminal history. It is substantial. However, any monetary bail is going to operate as a no bail hold in this case. And there is an actual hold out of Reno Justice in the other case, given the PC sheet, which I know you read, indicating that it was a fairly low gross gram weight when considering the packaging of that 4-point gross gram of meth. A no bail hold is not, what amounts to a no bail hold is not commensurate with the alleged offense. We will not be able to hear back from Melissa until later, but client believes that he could stay with her, and on that I'd submit.
Okay, well, And where does she reside? 1801 West Fourth Street, Unit 35?
No, I don't know what unit number it is, but yeah, it is 1801.
It's a different unit number, but that is the address.
All right. Given his failure to appear and comply, substantial drug history, bail would be appropriate, $10,000 or 10% cash, should be subject to testing. Should not possess firearms or weapons. He'll have supervised check-ins with DAS. And provided they can verify that he has a place to live with Melissa, 1801 West Fourth Street. Reno, they can verify that and he posts and it'll be released subject to those conditions.
Thank you, Your Honor. Go ahead.
All right. Next is Carlos Diaz, followed by Joe Melendez.
Well, Your Honor.
All right. Get Mr. Diaz file up here. All right, so is the state ready to proceed with Mr. Diaz?
Yes, Your Honor. So in this case, we are asking for $20,000 bail, DAS supervision, as well as GPS monitoring, house arrest. The defendant has a criminal history going back to 2002, petty larceny in Reno Municipal Court, obstructing and petty larceny in Sparks Municipal Court, had a 2003 graffiti in Reno Municipal Court, 2008 conviction for attempted grand larceny here in the second judicial, had a 2010 possession of drug paraphernalia in Sparks Municipal Court conviction, had a more recently a 2020 resisting, had a 2024 graffiti in Sparks Municipal Court where he was on a suspended sentence. And then here has a felony arrest for possession of a controlled substance that was, my records show that he was set for entry of plea on November 6th for misdemeanors, but I think looking at the facts of this case, that may be in jeopardy now based on there was some, he was supposed to essentially toe the line as far as I read the offer for that entry of plea. And so here, again, based on his multiple prior graffiti convictions, this appears to be an issue for him over 20 years. And then just the list, which I know Your Honor has reviewed in the PC sheet of the different locations of the graffiti in this case, he's absolutely a risk to this community. And with the fact that he was pending a controlled substance case and is still out in the community committing these acts, believe that he's not amenable to supervision. We would ask, though, if he were to make that $20,000, that he be subject to testing, as clearly that's a recent issue for him. And with that, I'd submit it, Your Honor.
And Ms. Meyer.
Thank you, Your Honor. Your Honor, we would join in all of the conditions except for the monetary bail. I believe that the GPS monitoring should be sufficient to track where Mr. Carlos is going. And I think it's important, assuming that the state is able to prove the allegations in this case, it seems like a fairly hefty amount of damages as I read it. In this case, we were able to confirm that Mr. Carlos is working with Southern Glacier. He has worked there for over a year. He has a place to live at the 435 Right Way address in Sparks. He has the ability to transport himself to and from work. Given if proven with these charges, the most significant impact is the cost on the city and owners to undo the damages of graffiti without admitting fault. It seems that getting him out and working actually is the best way to secure community rehabilitation. I understand the court's testing. I think GPS monitoring and testing are appropriate and established by the facts. We would simply ask that this court find that to be sufficient under Valdez Jimenez, as the state cannot clearly and convincingly prove that monetary bail in addition to those are required for safe release into the community. And on that, I submit.
So you were able to verify that he lives at, you said 435. The assessment said 433. Is it 435 or 433?
It's 435. I moved to the bigger place next door.
Okay. All right. Because court services had 433. All right, so I'm gonna set bail for him because some bail is appropriate. His bail is gonna be $10,000. All right, given the fact that he's gonna be subject to residential confinement, fitted before release, he'll be subject to testing. All right, other conditions would be he must reside at 435 Right Way, and he'll be subject to supervised check-ins with DAS. All right, he admitted to doing this over the when he's having a conversation with his son at the jail that he couldn't stop. But I think residential confinement will help in that regard. All right,
Thank you, Your Honor.
next is Joe Melendez, followed by Carlos Rivera Mitchell. All right, is the state ready to proceed?
Yes, Your Honor, with Mr. Melendez, we are asking for $7,500 bail, DAS supervision, testing for alcohol and controlled substances. Defendant has criminal history going back to 2013, wherein he was convicted of a DUI here in the Reno Justice Court. Had a 2016 DUI second in New River Township, which is in Fallon. Had a drive on a revoked driver's license in New River in 17. 2020 misdemeanor conviction for possession of drug paraphernalia in Sparks Municipal Court. Had a 2022 possession of drug paraphernalia in Sparks Justice Court, where he had a suspended sentence revoked. He had a misdemeanor conviction for criminal contempt in Fallon Municipal Court in 2023. And then he has a possession of a controlled substance case that's pending, where he failed to appear just in August after having a pretrial violation report that he was not complying with supervision. So based upon the lengthy issues with controlled substances and convictions, therefore, kind of over this Northern Nevada area, fact that he was already subject to supervision and had issues there, we believe that he is a risk to the community, risk to not appear given that failure to appear back in August, and believe that bail as well as DAS supervision and testing are appropriate. Thank you.
All right, Ms. Meyer.
Thank you, Your Honor. Your Honor, I don't disagree with anything the state said. I just don't believe monetary bail is the appropriate way to deal with that. Again, under our case law and the Constitution, which presumes innocence. I think in this case, we've got substance abuse testing and daily check-ins and ankle monitors in order to reduce both the limitations on freedom for clients as well as the cost of incarceration for taxpayers and the jail. So I believe that the most appropriate for both of those, especially given the history being surrounded by not even sales, but really what appears to be the behavioral health crisis of addiction, the best way to deal with that is an ankle monitor and daily testing. It's also the most efficient for taxpayers. On that, I submit.
Okay, I just want to make sure make sure my notes are right. This other FTA warrant, that bail has been set at $15,000, correct?
That is correct, Your Honor.
Yes.
Yeah,
The other case.
all right. So I'm gonna set his bail at 5,000 or 10% cash. He will be subject to an ankle monitor. He'll be subject to testing, and they'll have supervised check-ins with DAS. Some bail is appropriate given his record and his high risk assessment. All right, next is Carlos Rivera Mitchell.
Your Honor, on this case, I am actually asking that we continue 2 days. We were able to attempt to reach out to Victory Outreach I know that this court is, and all courts are concerned with the ability of unhoused folk to show up. I'll be back here on Sunday and I'd like the ability to confirm whether or not he could reside at the Victory Outreach Center there.
Okay.
Is
State
that all
have
right?
any objection?
No, Your Honor, I'm here all weekend, so no problem by me.
All right, so, make sure I understand, Ms. Meyer, do you want us to continue this till Sunday? Give you enough
Yes, Your
time?
Honor, if possible. That way I can maintain oversight on it.
Okay, all right, so be continued till Sunday.
Thank
Okay,
you.
next is Richard Thompson, followed by Joseph Watson.
Come right here.
Okay, so before we proceed, just bear with me here. Well, I did the warrant in this case. His risk assessment is 3. I just want to confirm on the public defender side. Your reported monthly income exceeds the requirements for an appointment of public defender. Are you still? Well, let me get you to raise your right hand first of all, sir. I need you to raise your hand. Do you swear to tell the truth, the whole truth, and nothing but the truth under penalty of perjury? Get a yes from you, please.
Yes,
All right, he's still employed with A1 Home Services as a carpenter.
correct.
All right, is your reported monthly income 3,100?
No longer. My boss moved to Kentucky.
Oh, so you're not employed there anymore?
I have 2 more days of work and then no.
Okay,
I was actively
so-
looking for employment.
okay. I just needed to verify that. So. Let me check one thing. It looks like you rent, correct?
And Your Honor, just to sort of anticipate the court, we were able to
Right.
confirm with Jess, his roommate, that he has been at his rental property for approximately 4 years, though it might be as short as 3.5. That is the residence 325. That the anticipation is that Mr. Thompson would be able to secure employment and stay on at that residence for approximately a month or so, given sales and given savings and negotiation with roommate.
All right, so is he then, he's residing at 325? Let me just check my notes here. They were able to verify his residence at 325 Westbrook Lane, correct?
Yes, Your Honor.
Okay. Okay, so we got that part of the way, so I'm gonna appoint a public defender to represent him in this case. All right, is the state ready to proceed?
Yes, Your Honor. So Your Honor, I note that he does have an MPRA of 3. The only conviction I could find for Mr. Thompson was a 2002 possession of marijuana in Tacoma, Washington. Given the kind of facts and circumstances of this case, I do not object to an OR. I would ask for DAS supervision. Again, there's concern, I think, here. I mean, above and beyond the CCW, but the fact that it appears that he was intoxicated and there's some history of drug use in the past. So we would ask for DAS supervision with testing for alcohol and controlled substances. And I would also ask that DAS confirm that he has no other firearms and that they be turned over for safekeeping to DAS during the pendency of this case if he does. And with that, I'd submit it. Your Honor.
Yeah, so I would agree, because I actually did the warrant on this case, given the circumstances. And he was truthful with the officers to a certain extent. So I am gonna go ahead and release him. He will be subject to testing, shall not possess firearms or weapons. DAS must confirm that he's forfeited those weapons. And he must reside at 325 Westbrook Lane, and he'll be subject to supervised check-ins. All right, yeah, given the
Thank you so much.
circumstance of this case, and his low risk assessment, he's gonna be released.
And Your Honor, may I have court's indulgence just one moment?
Sure. Pardon me? Right, so November 18th is his next hearing date.
Thank you so much, Your Honor.
Okay, next individual is Joseph Watson.
Good morning, Your Honor.
Morning. So is the state ready to proceed with Mr. Watson?
Yes, Your Honor. And so I would note that we reached out to the victim in this case. I don't believe she is going to be present today, but if I may double check with Madam Clerk that there's no one here. Glenalyn, Benan, Kristen.
No, we had nobody log in.
Okay, perfect. So yes, Your Honor, in this case, we are asking for $10,000 bondable against this defendant. Concerningly, when my investigator reviewed the jail call logs, the defendant has been trying to contact the victim multiple times while he was in intake. When we reached out and spoke with the victim, she'd indicated that she knew he was calling, but she was at work. And so I don't believe that any of the calls were taken. But again, concerning given the fact that this is a TPO violation and he's hitting the jail calling her again. The defendant has criminal history. He has got a 2022 misdemeanor conviction for DUI in Carson. And then he has an arrest from about 2 weeks ago for domestic battery that's currently pending in Reno Municipal Court case, still active. Looks like that doesn't have a status hearing for a little bit of time here. He bailed out at $3,000 on that case. I think that's significant in that the victim indicated to us that the defendant's mother called her and was complaining, saying that this was her fault, that now they're going to lose the $3,000 that they already posted in the Reno Municipal Court. And that, again, I think that's concerning given the TPO, the fact that it's clear that third parties cannot contact individuals on their behalf. And so ultimately, when we spoke with the victim, she had indicated that she was trying to cancel or to annul the TPO.
Yeah,
However,
she wanted to dissolve it.
she wanted to dissolve it, and she indicated to us that she wasn't trying to extend it and wanted to cancel it. However, in the state's view, we would ask for the TPO and pursuant to NRS 178 that it be a subsequent offense. The defendant, again, is pending a domestic battery case in Reno Municipal Court. And despite the
Is
fact
that the same individual? Is that the same individual?
I could not tell from reviewing the case specifically. It did not list her name in the case on Reno Municipal Court. And I
All right.
didn't note that from my investigator's notes either. But what she indicated to my investigator was that the reason why she wanted to remove the TPO is because they both work at Panasonic, and that they ride together on the bus. And so it's more an issue that she wanted to remove the TPO so that there's not an issue with them both riding the shuttle together to work. She indicated that the defendant's manipulative and that he drinks often and smokes something, but she didn't know exactly what it was. That he has many guns, and his parents had picked them up from their apartment. Um, it She also indicated that she was concerned. I think it sounds like they have that she is concerned about residing with him, but that she has issues financially and is concerned about breaking the lease. And so, what this adds up to in the state's view is that, again, the notifying the TPO was not so much of we need to get back together, but a concern for her own financial stability, which we often see in these types of domestic cases where the one partner has financial control in the scenario, and the fact that they both work at the same location, and that again that feeds back into the financials. And so, the victim in the state's view was in a vulnerable position, being called by the defendant when he's booked in for contacting her, has his parents essentially calling and harassing the victim, blaming her for these issues when it's clear by the paperwork that he can't. And oftentimes I hear the courts say, doesn't matter if the person contacts you, you're the one that's going to get in trouble. And again, he's pending that domestic. And so this is a concerning case in the state's view of kind of that power and control dynamic and manipulation. I would note that the victim indicated that she's here from the Philippines and English is her second language. And it sounds like she has some issues kind of navigating the justice system here in the US based upon that. And so, again, we believe that the $10,000 bondable is appropriate given all the facts and circumstances of this case and the pending case, that the defendant be tested for alcohol and controlled substances, that he have no contact with her pursuant to NRS 178 such that it's a subsequent offense, and that he have no possession of weapons as well, given the pending crime of violence and the report that there was weapons, although it sounds like they were removed to the parents' house. But again, if he's not residing with her, I believe that's probably where he would be residing, is with his parents' house. But with that, Your Honor, I would submit it unless the court has other questions.
All right, so let me ask Ms. Meyer this. Were you able to verify his address at 103 Pebble Drive, and were you able to verify his employment?
Your Honor, if I can just back up for 1 second, I was able to verify the employment. We were able to speak with the alleged victim. She identified herself as Gina to us, but it was that same telephone number. I believe that's what she goes by. She did say they are both working at Panasonic, that he had been living at the Pebble Drive. The state is correct that he would be living with his parents in Dayton. We have confirmed that they would make plans for an alternate placement for those firearms. He understands that he cannot be in actual or constructive possession of those should he go to his parents' house. So it would not be at that Pebble Street, but would be in Dayton. And work was confirmed, which, as well as the cell phone, which brings the risk assessment number down to 4 from that 8, which puts it in the low risk to reoffend, as well as the absence of criminal history except for that DUI in 2022. I think that all mitigates for the non-monetary bail, but with the testing, I do have to say also, Your Honor, I'm slightly concerned. There's a reason that Marcy's Law has been put into the Constitution. I understand that we have experience, and perhaps it's a little bit pot calling the kettle black, given how I described instruments of knives being used by unhoused individuals. But Mr. Reichenberg seemed to be closely approaching testifying as an expert on dynamics of coercive control, on what Miss Gina actually wanted versus what she said she wanted. Her views do count. She's not here, but I would say that we spoke with her.
Let me stop you right, Ms. Meyer, let me stop right there. I don't disagree with you. I think given the circumstances of this case, with the right conditions, he could be OR'd. So that's why I asked about his that. So the 103 Pebble Drive is his parents, correct?
Yes, Your Honor.
All right, you're gonna reside there, is that correct?
Yes, Your Honor.
And do you know if you're still employed by Panasonic?
I know I was terminated due to the PTO itself, but that's why I was trying to go ahead and get it removed so I can go ahead and start putting money on the table and start getting myself back on my feet.
So you're currently unemployed, right?
Currently, you're correct.
Okay. All right. Let me change a couple of my conditions here. All right, so given the circumstances of this case with both parties were in the car together going to family court, it looks like, to dissolve the TPO, and based on what she's told the state, I'm gonna go ahead and OR you with the following conditions: no contact with gentleman or Bynum Christensen. All right, pursuant to statute, means you cannot contact her. That means you cannot have anybody else contact her on your behalf. To ensure that, you're going to be subject to residential confinement fitted before release. You shall not possess firearms or weapons. DAS must verify that you have no weapons. You must reside at 103 Pebble Drive, which apparently is your parents' home in DAS. And then you must provide DAS with proof of employment within 60 days, and you'll have supervised check-ins for DAS. Got to meet those conditions. All right, I'm going to go ahead and release you given the circumstances of the PC sheet.
Thank you,
All
Your
right.
Honor.
Okay, next is Royce. I'm not even going to try to pronounce the last name. It looks like we have an arraignment for Royce as well as a bail hearing. All right. So I have a criminal complaint. Is your client going to waive a formal reading?
Yes, Your Honor, his name appears truly incorrectly at line 7. He is familiar with the sole charge in the criminal complaint. He would waive a formal reading.
Okay. All right. So is the state ready to proceed with Royce?
Yes, Your Honor. So I would note, it looks to me like the warrant was set at $5,000 bondable. In the state's view, we are asking that it be set at there be raised at $20,000 bondable. Again, concerning facts for order and safety in the jail. Also, due to the fact that the defendant's criminal history, so he's got an MPRA score of 12. In 2023, he had a felony conviction for discharge into a structure in Carson City. Had a 2022 misdemeanor conviction for DUI in Carson City as well, where he also had a firearm under the influence and discharging a gun charge that was dismissed as part of that DUI plea. Had a 2013 burglary arrest that looks like it was no issued in Lyon County. And then has some older Pyramid Lake criminal charges that I have no dispositions for, a battery and resisting, as well as violating a court order in 2007 and an assault again that was in 2009. So older Pyramid Lake history with no disposition. But given the violent convictions and the apparent propensity for weapons in the last few years in his convictions in Carson, we believe he's a risk to the community and believe that a higher bail is appropriate with DAS supervision and no weapons. Thank you.
All right. Ms. Meyer?
Thank you, Your Honor. Your Honor, we were able to reach out to Stephanie. He left a job that would hire him back. That was with, I'm so sorry, Your Honor, that was with Dane Valley Turf. He does have a place to live, and that would be 500 Palomino Street in Nixon. I understand that that's a slight bit away, but I think it's about a 45-minute drive. He indicates that he would have the ability to go back and forth with transport. I understand the state's concern with that NPRA score. However, I would submit that given the residence, the contact, and the work that reduces it to, I believe, a 9, which is still a high risk, but given the nature of the charges, and I didn't see a failure to appear history, I would ask that this be an enhanced pretrial supervision, and if a monetary bail is going to be put on, that it not be increased, but even potentially set at OR. And with that, I'd submit.
Okay, so I just want to make sure. You said 500, but the pretrial assessment report said 5,000. Is it 500 or 5,000 Palomino?
Your Honor, 5,000.
500.
Okay.
Oh, 500.
500?
I just assumed I was going blind, Your Honor, and need readers, but apparently it was someone else's mistake today.
Okay, so 500 Palomino. And then you said you were able to verify his employment at Dayton Valley Turf?
Able to confirm that it is Stephanie's understanding that he would be able to be rehired. He has been incarcerated, and so he is not presently on the books or collecting money, but it is her understanding through her connections in that community that he would be rehired. Does that make sense?
Okay. Yeah, it makes sense.
Thank you, Your Honor.
All right, so. Let me just complete my GRO here. So. Who's Stephanie?
She's a friend.
All right. All right, so Judge Clifton had set the bail at 5,000, so I'm gonna leave the bail as is. Remain at 5,000, to be subject to drug and alcohol testing, so shall not possess firearms or weapons. It's verified by DAS. You must reside at 500 Palomino, which is the address in Court Services, Nixon, Nevada. In addition, DS must verify that you are employed either through Dayton Valley Turf or other employment within 30 days. You'll have supervised check-ins with DAS. All right,
Thank you, Your Honor.
Do we want the mandatory status conference or a preliminary hearing?
Court's indulgence, please.
so we're doing that for all ones. Mandatory status conference with.
Just because this is a felony.
Got it.
I have to call for it.
And on the fugitive, all we do is set a hearing, right?
We're just confirming he's.
Yeah.
I think it's right. I want the way, I want you to do it right here, but I'm taking care of it. That's fine. This.
This for the one.
Yeah.
Yeah, so I was just, I wanted.
Your Honor, he's waiving his right to a speedy. I would ask that this court set it at as an MSC if, please.
Thank you. December 2nd at 1:30.
Thank you to court and counsel. Happy Halloween.
Oh, we need
We
to
have-
do the first appearance for
Yeah,
Alexandria.
one more.
Just the first
Your
appearance
Honor.
for Alexandria Killian. It's a fugitive matter.
We just
Your
need
Honor,
to set a hearing.
She waived.
Perfect. Thank you.
All right. All right, y'all having a good weekend.